Item 1. Take emergent notice. You take notice for?
No, your lordship will kindly see.
Allotment he has sought for, not at your hands.
Yes.
You appear for all of them?
No.
The emergent, Mr. Lenka, AG accepts notice. He is requested to accept notice for 1. The emergent notice to 2 and 3.
Yes.
Yes. Item 2.
Please, your lordships. The lordships present petitioner challenging the order dated 30 June 2025.
26-25.
Yes.
What is that order?
Order reject the pending dues of financial year 2021-22, your lordships.
Lenka accepts. Any private party?
No, your lordships.
Matter lies in a narrow compass posted the last week of November. Item 3.
To challenge the order of transfer in Annex 3, the transfer has been made based on the local MLA and it is violative of guidelines.
When it was made?
Transfer order was passed on 23/9/2025.
No.
Before just.
Are you relieved?
No.
You are not relieved?
Perhaps not. I don't.
You don't know
what information. But he is
emergent notice.
Your lordship has previously passed one order
of notice for 1, 2, 3. Emergent notice to 4. Stay of an application is moved for staying the interim transfer order.
So far it relates to the petitioner.
That's one. Order to the extent it relates to the petitioner. First, Mr. Lenka submits that if the petitioner is already relieved, no purpose would be served by staying the impugned order. First, counsel for the petitioner submits that in more than 24 matters, interim protection has been granted to employees of the client, and therefore the same cannot be denied to his client. First, next one. Having heard learned counsel for the parties and having perused the petition papers, the impugned order is liable to be stayed, and accordingly, application is allowed. First off, however, the stay shall not take effect if the petitioner is already relieved from the post in question. Okay. Call this matter along with WP number.
Yes.
Okay. Item 4. Differential arrears of salary.
Yes.
Any representation is given. Who appears?
Representation Annex 5.
Yeah, that consider that representation.
Annex 5 is based on
short grievance of the petitioner is reflected in the prayer column. First. And a representation dated 7/1/2025 has been addressed to district education officer seeking release of differential arrears of salaries as well as the current monthly salary in trailed graduate scale of pay from the date of attaining the age of 48 years. First, the prayer is innocuous. First, next paragraph. Learned AGA appearing for the petition.
Similar.
Now you are giving. Appearing for the OPs. Agrees to instruct OP number 2.
OP 3.
3 to look into the grievance of the petitioner as has been here subject representation if all contentions are kept open and a timeline is prescribed. This is appreciable. Next one. In the above circumstances, petition is disposed of 8 weeks. Contentions kept open. It is open to solicit. Now go first.
Prayer person may be quoted. Prayer person may be quoted.
Yes, I have quoted. Oh, yes. Item 5.
Item 5, may I please, Your Lordship?
Yes.
Your Lordship, this is regarding the grant of UGC scale of pay, Your Lordship. The petitioners are demonstrators, Your Lordship. Your Lordship was pleased to issue notice in similar matters, Your Lordship.
To emergent notice. Mr. Lenka is requested to accept notice for all respondents. All respondents? No. 1, 2, 3. Emergent notice to OP4. OP4. Call this matter along with which are the connected matters.
21845 of 2025.
WPC 21854 of
21845
of
2025.
okay.
Item 6.
May I please answer?
Yes, doctor.
The petitioner's limited grievances is that he has applied for legal head certificate under miscellaneous certificate rules 1984.
It is still pending.
It's still pending since
Where it is
5
pending?
Athagar, Tahsildar Athagar.
You consider it in an expeditious way?
Yes.
Yeah.
Lordship, other two matters are similar as well.
Same matter.
Yes,
different
my
matter.
lord. Yes, my lord.
In all these petitions, the short grievance of the petitioners is as to long pendency of their claim for the issuance of legal heir certificate that may be required for several purposes. Several purposes. First off, counsel for the petitioner vehemently argues that OP number 3 is not justified in keeping the matters pending without realizing the consequences of such a pendency or delay in issuing of certificates. First off, she also says that the right to speedy justice is a facet of Article 21 of the Constitution of India in the light of a catena of decisions of the Apex Court, and therefore OP number 3 be directed to hear and dispose of the claim for issuance of the said certificate. First. Next person. Mr. Lenka, the DG, on request appearing for the OPs, submits that Tahsildar happens to be an ex officio officer under as many as 13 statutes in the state, and therefore he will be under tremendous pressure, and therefore no timeline be fixed for disposing of the matters, although he would instruct him to take an expeditious decision if all contentions are kept open. First, next paragraph. Having heard the counsel from the parties and having perused the petition papers, this court is broadly in agreement with the submission of the net counsel appearing for the petitioners. Petitioner. First up, this court has said, first up, the legal heir certificates are needed for several purposes and for availing benefits under various schemes, including rehabilitatory employments. First up, there are timelines for applying for such benefits. And if applied belatedly, the claimants run the risk of rejection of the claim. First of all, this needs to be kept in view by OP number 3. First of all, next paragraph. In the above circumstances, petitions are disposed of. OP number 3, Tahsildar, is directed to hear and dispose of the claim for issuance of legal heir certificates within an outer limit of 4 months. 4 months. After hearing all the stakeholders, first of all contentions are kept open. Next.
Item 7.
Next.
Petitioner is a retired headmaster. The file of judicial from matter related to area salary. Similar matter already issue notice, madam.
Issue emergent notice. Lenka is requested to accept notice for
Both the parties. Opposite parties.
both of it. First of all, call this matter along with WP. Next.
Connected matter also same.
Item 8.
May I please, my lord?
Yes, sir.
My lord, this is a matter of junior lecturer in government college, my lord. He is eligible for one advance increment.
You should notice any representation is made.
Annexure 7.
Annexure 7, if is directed to be considered, will you be happy?
My lord, government order is there also to decide the matter at Annexure 7, page 31.
Yes, I will tell them to decide it within 3 months.
Yes, my lord.
Okay.
All right.
Grievance is reflected in the prayer column, which is scripted as under. Next one. Learned counsel for the petitioner draws attention of the court to a series of representations at Annexure 7, seeking the fructification of the prayer. First off, however, no decision having been taken on the said representations, he is knocking at the doors of writ court. First off, learned AGA appearing for the OPs, in all fairness, submits that he would instruct the OP number
OP number 2, my lord.
Two.
Director, yes.
to take calls on the subject representations if all contentions are concluded and a reasonable period is prescribed. First off, with this proposal, counsel for the petitioner is agreeable. Next balance, 8 weeks, open to solicit, now no cause. Contentions kept open. Yes.
Item 9.
Lord, wait, please, Lord.
Yes, sir.
My lord, I manufacture insecticides. And my lord, the OP number 2 is one Agrim Wholesale Private Limited, which is selling this product in the state of Orissa. Now, under the provisions of the Act, my lords, the Insecticide Act, for manufacture and sale, both ways you require a license.
For manufacturing and sale.
Suppose I'm a manufacturer, I have to take a license.
And if he is the seller,
He is the seller, he has also to take a license, and he has to take a license in respect of my insecticides. There are various categories of insecticides. Your lordship knows these are hazardous and poisonous stuff. So these are highly regulated. The law mandates, my lords, that whoever is manufacturing, whoever is selling also must take a license. And for selling my product, he needs a clearance from me. When he will apply for license, he has to say that I am going to sell this product manufactured by Mr. Parija, and this is the certificate he has given. That is called a principal certificate. Because, my lords, I also have to take responsibility
if something happens.
if something happens. I'm grateful to your lordships. Now here, this Agrim,
It is like Ryland versus Fletcher.
your lordship is, my lord, your lordship. So now, he is selling it without any license from me, and every day I am incurring a problem if something happens there.
If something happens, action will be taken against you.
I am grateful. So therefore, my lords, I made an application to the government of Orissa. I say that you please take action. That is pending. That is one part of it. The other part it is, not what is troubling me is, my lords, I want a protection from your lordships that he will not sell my insecticides. And your lordship may say that he will not sell my insecticides till he has a license for the same. Till he has a license for the same. And if your lordship want to see this act and the rules, I'll show you that.
I'm conversant with
Yes,
that,
yes.
because
I'm grateful. That's all I'm seeking. In West Bengal also, this gentleman was doing the same thing.
What Calcutta High Court said.
And the Calcutta government, West Bengal government itself took action. And your lordship may kindly see page 63. I'm so sorry, Miraj. Page 69. Annexure 7.
Annexure 7.
Not in respect of my product, but somebody else's product.
Very same respondent.
Same respondent. To Agrim. This is the order passed to Agrim. If your lordship sees, my lords, to Agrim Wholesale Private Limited, etc., complaint letter so and so, where it has come to the notice of this office to a routine complaint submitted by so and so, having its registered office and so, is allegedly involved in authorized, unauthorized online sale of insecticide products manufacturing by the complainant in the state of West Bengal. And whereas it has been alleged that your entity is not an authorized distributor licensee of Dhanuka Agritech Limited, and has not been granted valid principal certificate or authorization for the said insecticide under Insecticide Act 1968 and the Rule 71 to distribute or sell the proprietary products either physically or through online platform. Now, whereas as per Rule 10E of the Insecticides Rule 71, every e-commerce entry online platform must ensure that no person shall sell any insecticides through e-commerce without verifying the valid license issued by the competent authority, licensing officer under Rule 9. Now, therefore, in exercise of powers vested in the Insecticides Act 1968, rules framed thereunder, you are hereby directed to immediately seize and resist. Seize and resist is what I'm asking for.
In the online, right?
Seize and resist from the online sale, advertisement, promotion, offering for sale of any insecticides produced by so-and-so or any other company, so-and-so, as per their previous correspondence in this regard.
What do you say?
No, your lordship may direct the state government to dispose of the representation.
No, till then, suppose if he sells and then something happens, tomorrow Mr. Parija will be arrested.
I think his, my learned senior submission that whether he is selling or not, that is a question. So when matter is pending before the, only on 10th September,
3031, I have given photographs of his godown.
Of your products.
Yes, my product. Your lordship may see page 35.
Mr. Parija, I am asking a question. Please.
Yes.
Suppose if I direct consideration of the
Yes, and in the meantime, you will not sell my products.
that will be direction to the private party.
The private party. Well, let them dispose of the representation. In the meantime, your lordship may injunct him from selling my products and kindly see,
for that I have to hear.
Yes. Then your lordship may issue notice.
Yes, sir.
Your lordship may issue notice.
Issue emergent notice. Learned AGA Mr. Lenka is requested to accept notice for the first OP. Emergent notice to OP number 2. First, an application is moved seeking interim restraint order against OP number 2 from selling the products of the petitioner. First of all, learned senior advocate Mr. Parija, appearing for the petitioners, draws attention of the court to the provisions of Insecticides Act 1968, which regulates and controls not only the production but sale and distribution of insecticides. First, he submits that under the scheme of the Act, not only the selling agent will be liable, but also producer is and manufacturer is, and therefore the OP number 2 needs to be restrained from dealing with the products of the petitioner company till disposal of his subject representations takes place at the hands of OP number 1 or its functionaries. First of all, there is force in this submission. Next paragraph. In the above circumstances, application is allowed. Second, OP number 2 is restrained from selling or dealing with the products of petitioner company, selling or otherwise dealing with the products of petitioner company till next date of hearing. Since I am disposing of the application, I will not say till next date. Let him apply for.
Yes.
Restraint form. It is open to the OP number 2, who has been injuncted ex parte to seek variation of this order if grounds do exist there.
Grateful.
Yes.
Item 10.
Grateful, brother.
One second, Mr.
I'm so
Bari.
sorry.
While issuing this interim protection, court has noted the order made by Government of West Bengal against OP number 2 in matchable
Annexure 7.
Annexure 7 order. In matchable situation.
Item 10.
May I please, my lord?
Yeah.
This case is covered by your lordship's judgment in the case of Lokanath Behra, my lord.
Not there.
My lord, the similar order, your lordships.
This was.
This is a corrected copy, I'm serving.
Yes, they are corrected.
My lord, I have corrected.
Yes, once. You have served copy on your senior friend. Yes.
Item 11.
Identical to that Haraprasad Rai, my lord, have already on 15th disposed of another matter of the same institution.
Have you given a copy to them?
I'm good. Yes, sir. Annexure 5 series is to be disposed of. That is the recommendation.
Have you changed?
Yes. Only change the necessary correction. Only Annexure 5 series. That there it was Annexure 4. Yes, absolutely.
Mr. AC.
Page 19. Page 19 is the representation.
All right.
Item 12.
Please, my lord.
Yes.
My lord, the petitioners here are bona fide title holder and peaceful possessor of their ancestral property. Now, the opposite party number, so but the khata number 220 as well as the khata number 330, now they are creating a third party interest. Now,
Who are creating?
the opposite party number, that is CDA.
Is it a private party or a
No, government, CDA. Kotak Development Authority.
How they are creating that?
When the matter is also subjudice before the Hon'Ble High Court as well as the Hon'Ble Apex Court.
In another matter, there is
Similar matter, but not this
other connected matter.
connected matter. So that now they are also trying to allocate the plot in the name of the different persons.
Issue emergent notice. Learned ASC accepts notice for OP numbers 1 to 3.
1, 2, 3, 6.
1, 2,
So also, my lord, 6 to 9, my lord.
6 to 9. All are the government.
and 6 to 9.
My lord.
Sir.
Emergent notice 2,
4 and 5.
4 and 5.
Same.
4 and 5. First up. Learned counsel appearing for the petitioner draws attention of the court to IA number 17026
Sir.
of 2025, seeking an interim order to restrain application of interest in the subject properties by which Kotak Development Authority,
CDA. Open numbers are 5.
OP number 5, in favor of third parties without any justification. First off, he also tells the court that right to property is constitutionally guaranteed under Article 300 capital A of the Constitution of India, as widely construed by the Apex Court in which is that name?
Keshavananda Bharati.
Huh?
Keshavananda Bharati was state of Kerala.
No. Just right now, Karnataka Leaching Limited versus 2011 judgment. Anybody knows that? Anyway, all right. And first, next one. Having heard the net counsel for the petitioner and having verified the petition and application papers, this court will have considered that the interim protection needs to be granted so that no prejudice would be caused to the petitioner during the pendency of the petition. First, in view of that, application is favored, and OP number 5 is restrained from dealing with the subject properties by the khata number 220 and 330.
330, that's what
30 during the pendency of the petition. First off, if any party is aggrieved by this order, it is open to them to seek variations, its variation by if grounds do exist. If grounds do exist. Okay. Next.
Okay, sir. Item 13.
May I please?
Yes.
My lord, here the petitioner's grievance is, my lord, they were initially engaged as graduate teachers on contractual basis.
Shweta Padma Samal.
Well, the difficulty is I am relying upon Shweta Padma Samal and relying upon that judgment. Various orders have been passed by this Honorable Court. But that matter is pending in the Honorable Apex Court.
Any stay is granted?
My lord, stay in that particular case has not been granted, but in the batch of cases, stay has been granted. My lord, therefore, my endeavor before your lordships is another judgment of the Honorable Apex Court from Karnataka High Court has come, dealing with the same points. Your lordship may kindly see that.
What it says?
It says, relying upon, my lord may kindly see, relying upon Rule 17 of the pension rules. My lord, the Honorable Apex Court has directed, your lordship kindly turn to page paragraph 9 of that judgment. Here, there is a perimetry provision like Rule 17 of Karnataka pension rules, also in Orissa pension rules, that is Rule 14.
They interpreted it in the light of Sheila Devi.
Sheila Devi. And my case is squarely covered. So instead of Shweta Padma,
pre-regularization service also needs
to be counted for the purpose of pension. So instead of Shweta Padma, your lordship may say that, my lord,
what they say now?
My lord, they say that you are not entitled.
They have said it already.
No, they have not said it.
But the
representation is pending.
Let them consider the representation in the light of this.
My lord, representation I have structured in the light of Shweta Padma. Since
Shweta Padma, from their law again has marched further.
Yes.
Because of this.
Yes. So your lordship may direct for consideration of my case in the light of this judgment. Shiladevi पर एट अपरा SD Jayaprakash pra एगुटा देखो
which one?
This one he says this one SD Jayaprakash.
Okay. This vacation he is writing a book on law of service.
Along with
he will be writing the forward to that.
Yes.
Shiladevi has been referred to in that
SD Jayaprakash, which I am relying upon.
The short grievance of all these petitioners in these connected petitions is for an order to direct the consideration of their representations where kindly be seated.
Yes.
Wherein they have sought for counting of their pre-regularization service for the purpose of pension and other terminal benefits. First, learned counsel for the petitioner submits that in the light of latest decision of the Apex Court in it's not civil appeal number. It is granted. What is civil appeal number? The Apex Court reported in civil court, Apex Court in SD Jayaprakash versus UOI. Neutral citation is given.
Neutral citation.
2025.
Decided on 29th April 2025.
94. We expressed in favor of contention of the petitioners, and therefore the subject representations have to meet their fate at the hands of OP number 1, keeping in view the law declared by the Apex Court in the said decision. First off, next paragraph. Learned the ASC on request appearing for the OPs. What do you say? You will direct them to consider it. Agrees with the proposal of this court that OP number 1 shall consider the subject representations of the petitioners, keeping in view the Apex Court decision in SD Jayaprakash and also the other decisions mentioned in the representations only. First off, he caveats that all contention should be kept open and a reasonable period be accorded for undertaking this exercise. First off, with this stand of the state, senior counsel appearing for the petitioners is also agreeable. First, next one, in the above circumstances.
But as so far as other decision is concerned, since the matter is pending before the Honorable Apex Court.
Now this judgment has come.
Yes. Your Lordship may clarify that.
One second. Mr. Swain also, in all fairness, submits that the other decisions cited in the representation
That is what the
are pending before the apex court for consideration in SLs. First off, be that as it will. 8 weeks. We'll say 3 months.
3 months.
3 months.
All the matters are same. All connected matters are.
Yes.
Let them file a fresh representation because the entire representation based on the set of
Yes, yes.
They will be confused, my lord.
Yes, yes. You are right.
It is desirable that the petitioner shall file comprehensive fresh representations.
Yes.
So that the decision becomes, taking decision on them becomes easy.
Yes.
In the light of apex court judgment. Somewhere you can just that. Huh? Okay. Yes.
Item 14. May I please, my lord?
Yes.
The petitioner has constructed his house on his own landmark, but there is a government land just in front of the house of the.
So you want miscellaneous to be explicitly dismissed. It is of 2024.
24, man.
But the short prayer of the petitioner reads as that. Next one. Learned counsel for the petitioner submits that right to speedy justice extends to the criminal cases as well in the light of apex court decision, and therefore the criminal miscellaneous case number 1 of 2024 filed under section 133 of CRPC cannot be kept pending eternally. First off, there is force in this submission. Next paragraph. In the above circumstances, petition is disposed of, requesting the learned magistrate come.
OP number 2, my lord.
Requesting OP number 2 to try and dispose of the subject criminal case as expeditiously as possible and in any event within a period of 9 months. First of all contentions are 7 months.
Oh, not 4 months.
Oh, how? We said.
That the only
there are other cases also. This is not the only case.
inquiry has been made only all of these 2 things. Obliged.
All contentions are kept open. Registry. It hardly needs to be stated that the stakeholders should be given an opportunity of participation in the matter. First, okay. Registry to send a copy of this order to private parties. There.
My lord.
Private party.
To OP number
456.
6 by speed post immediately.
Obliged.
Yes.
Item 15.
May I please?
Yes.
Petitioner before your lordship challenging the illegal.
What is that 8/10/25 order?
My lord.
You are removed from the service.
Service. The transfer your lordship. 10 to 25 on Annexure 9. On page 27.
Go to another.
Even though the Annexure 20, the Annexure 8, on page 26, on 23rd of this year, 26 March 2025, I have been transferred. Again,
What is that photograph?
my lord,
What is that photograph?
photograph my only daughter, MR. Your lordship.
Daughter is not well.
No, MR. Your lordship. Your lordship, kindly see the.
There is the birth deformity.
Yes, yes.
By birth.
My bad.
Issue number 10 notice. Learned ASC requested to accept notice for all the OPs. First off, petitioner has moved an application in IA number 18195 of 2025 for interim protection. First off, he presses into service the order at
Annexure
8.
Annexure 9.
No, 9 is setting us order. You are pressing the order 8, Annexure 8 in support of your case.
Yes, Annexure 80.
The Annexure?
Annexure 8.
8 dated 26/3/2025 in support of this case. First off, he also brings to the notice of court the the position of differently abled daughter.
Only daughter.
Only daughter.
One.
Differently abled only daughter. Who wires sucker and care. This is going on and care. First, a prima facie case is made out for issuing interim protection. First, in the circumstances, application is allowed, and the impugned order is stayed, coupled with the direction.
Annex 9, 8, 10, 2025.
Impugned orders on annexures.
Annex 9, 8, 10, 2025. Running page 27.
Annexure 9. Dated 8/10/2025.
25.
Coupled with a direction to continue the petitioner as before. Okay.
Urgent certificate.
What more are?
Urgent certificate.
Yeah, it will be requested today.
Oh, like. Great.
Item 16.
First off, if this interim order is not complied, the defense of the OPs may be struck off and their counsel may not be heard in the matter.
Grateful.
Stop.
Lordship, 16, petitioner file for interest on delay payment of retirement dues.
Payment of interest on the delayed payment.
My lord, Annex 10 petition is pending.
Yes, brother, in the light of Padmanabhan Nair, you consider that.
My lord.
Yes. The short grievance of the petitioner is as to non-payment of interest on the delayed payment of terminal benefits. First, counsel for the petitioner presses into service the apex court decision in Padmanabhan Nair versus Union of India. Just look into it. Is it Union of India? Union, Mr. Raut, right?
Yes.
Union of India. Padmanabhan Nair.
Union of India.
I think 85 so. In support of the contention that pension is property in the light of DS Takara versus Union of India, and therefore, where delay occurs, interest is paid. He also tells the court that his client has made a representation dated
12/3
date of Kerala versus
12/3/2025, Annex 10.
Representation dated 12/3/2025, a copy whereof avails at Annexure 10, and in terms of that, no decision is taken by OP number.
OP number, controller OP3.
By the jurisdictional OPs, and therefore interference of this court is warranted. Next paragraph. Learned ASC appearing for the OPs opposes the petition, contending that settlement of terminal benefits is a big task. Several hands are involved in procuring the required information for processing the settlement of the kind, and therefore delay inevitably happens. Custom further says that ordinarily no interest is payable on the delayed payment. Custom, having so stated, still he fairly agrees with the suggestion of this court that the subject representation of the petitioner should meet its fate at the hands of jurisdictional OPs within a period of 8 weeks, if all contentions are kept open. First off, next paragraph. Ordered accordingly, and writ petition is disposed of. First off, the concerned representation has to be considered in the light of apex court decision in our state of Kerala versus Padmanabhan Nair, so and so, so and so. And also, which is that famous thing that Chandrasekhara Kambara versus Bangalore University, ILR, Science. Delay shall be viewed very seriously in the next level of legal battle. Yes.
Item 17.
17, I mean, permitted.
This matter relating to grant of arrears salary, you'll also already similar matter disposed of Annexure 8. I'm giving the corrected
Change
copy.
the factors.
Yes. Corrected copy of.
Yes, put off.
Same periods.
Yes.
Item 18.
Matter relating to appointment under the rehabilitation assistance scheme. Just day before yesterday, also you should notice the similar matter. But in the present case, my lord, in that case, you also did not incline to pass the interim order because petitioner already joined against the class 4 post. Here, my lord, I have not yet joined because the last date is 19th. Yes, for expiry of the appointment order. They have stated Annexure 5. 15 days time given to the appointment. Failing which the appointment shall be stand forfeited for all time to come. Yeah. And my claim, my lord, I am eligible for the post of Group C post.
But you join there and we'll see.
There is no kindly, without prejudice, also no kind for me.
But we issue emergent notice. First one, petitioner draws attention of the court to the application in IA number 18322 of 2025, seeking some interim protection. In as much as if he joins the post in question, tomorrow it may not be possible to prosecute the petition. First one. Learned ASC on request appearing for the OPs submits that let the petitioner join the post in question without prejudice to his contentions in the petition. First one. This appears to be fair. Next paragraph. In the above circumstances, this need be passed on the subject application at this stage. Yes.
Item 19.
You also give a letter.
Already
I have already filed WP.
Yes, I am
joining this post without prejudice to my.
Yes, today itself I have already. Yes.
Petitioner here, who is a widow old lady and purchased a land in 1985 and paying the holding tax and the land khajana receipt. But the opposite party number 4, 5 and 6, without any following the due process of law, now they are constructing the Anganwadi center over my plot.
On your property?
Yes.
We'll issue notice. We can't halt production so that tomorrow you can become the owner of the building also, if you succeed.
Yes, your lordship can issue notice.
ASC accepts notice for all OPs.
And status quo may be maintained, my lord.
Except next.
My lord, because Anganwadi workers, they have constructing now.
Let them construct. That building will belong to you only. You can go and stay there if you succeed.
Yes. Status quo may be maintained, may pray. Short date may be fixed.
Item 20.
May I please your lordship?
Yes.
My lord, here petitioner was serving as a BO in Puitola in the district of Balangir. Therefore, he has been transferred and posted.
Consider the representation.
My lord, there is
you have already rejected it.
No. My lord, representation is pending, but there is a specific guideline issued by the School and Mass Education Department where the service period is remaining within two years and spouse is working in the same district and they may be allowed to continue in the family.
You consider the representation and brother ASC. Consideration happens. Don't disturb him because his spouse is also there only.
Yes, my lord, that is true, my lord. But
and the retirement period is less than 2 years.
The guideline issued in the month of September 2025. He has been relieved in May 2025, my lord.
My lord,
he has been relieved. Page 16, my lord, on to May 2025.
You consider the
yes, my lord. Now I am on leave, my lord. Out of my early leave, I am able to leave, my lord.
Yes, but let him consider no interim order because that happened long ago.
My lord, there is also
consider the representation.
My lord.
Petitioner's grievance is reflected in the text of the prayer, which is as under. Next paragraph. Counsel for the petitioner submits. And learned AG appearing for ASC appearing for the OPs agrees that justice to the petitioner can be done if a direction is issued for considering his or her his representation dated 6/5/2025. Correct?
My lord.
6
No.
page 17 4 series, my lord. That is 24/5/2025.
That is the leave period. I was continuing till 23rd, my
Where
lord.
is your representation?
My lord, the representation annex.
Tell the date. It's in Oriya.
Yes, my lord, but translated copy also I submitted. Page 18, that is my leave application. I availed the leave from 24th May.
Not answering the question. Where is your representation?
Representation, my lord, annex 2, my lord.
Page
That
13.
is in Odia. Page 13.
Page 13.
No, page 13, that is my representation.
The petitioner, my lord, is a block education officer, is holding the administrative post.
Yes.
For considering the communication dated 6/5/2025 addressed to the Commissioner cum Secretary at Annexure 2 in a time-bound way. First, next paragraph. The one sentence, learned ASC deviates that all contention should be kept open. Next paragraph. In the above circumstances, petition is disposed of. 6 weeks. Within 6 weeks, you should consider.
My lord.
6 weeks.
8 weeks.
Policy in for
Lordship, 8 weeks.
Huh? 88 weeks. What is there?
No, all cases.
The spouse is there and within 2 years he is retiring. Still you want to disturb it. Yes.
Item 21.
Obliged, my lord.
Well, item 21, all the petitioners are approved staff members. And they are receiving their salary, but certain period of 7th pay differential area, so also SCP and RSCP areas.
Where is the
they have
representation?
they have submitted, the school has submitted bill under annexure 5 and 6 series. Let it be taken up in the light of government order 2 and 3, annexure 2 and 3. Let the annexure 5 and 6 series in respect of the area bill.
Petitioners, all these petitioners is reflected in the prayer column of the petition. First, counsel for the petitioner draws attention of the court to
Annexure 5 series and 6 series.
Annexure 5 and 6 series.
Calculation sheet, area bill.
Which reflect the calculation sheet as to the arrears of pay that allegedly remain unpaid to them with no justification whatsoever. First one. Next paragraph. Learned AGA, in all fairness, agrees that he would instruct the OP number 3, OP number 3, to take a call on the subject representation within a period of 8 weeks if all contentions are kept open. First one. With this proposal, counsel for the petitioner is also agreed. Next paragraph. 8 weeks open to solicit.
Well, taking into account annexure 2 and 3, there is direction district officer is to settle.
Happen, keeping in view. Annexure
2 and 3,
Annexure 2 dated 37/2018 and Annexure 3 dated 5/10/2019. Yes.
Item 22.
In response to direction of this Hon'Ble Court under Annexure 7, petitioner made
What is that representation?
representation for a grant of regular salary because the petitioner earlier daily wage workers, subsequently on the basis of the interview conducted by the opposite one note 3 and 4, they have been regularized under Annexure 5. And that has been sent it for approval for Annexure 6 by the opposite one note 2 and 3. But since it has not been considered, he approached this Hon'Ble Court and this Hon'Ble Court directed to file a fresh
In the light of Surendra Kumar Panda.
Panda, sir. Sorry, Annexure 8 has not yet been considered.
Petitioner has made a representation dated 7/4/2024, a copy thereof avails at Annexure 8, wherein he has requested to consider his grievance as per direction of his court dated 2/4/2024 in Surendra Kumar in WP.
Santosh Kumar Das.
Santosh Kumar Das.
Huh?
Santosh Kumar
Das.
In WP 7160 of 2024 between Santosh Kumar Das versus state and others. First off, the counsel for the petitioner quotes Article 350 of the Constitution of India to the effect that such a representation cannot be kept pending unconsidered. Eternal. Learned AGA, ASC, on request appearing for the OP, clearly agrees to instruct the jurisdictional OP.
Only OP1, madam.
OP1.
Others are university, madam. Barampur University.
The learned ASC appearing for OP number 1 tells that essentially the decision has to be taken on the subject representation at the hands of OP numbers 2 and 3.
No, OP number 1.
OP1? State.
No, state will be considered the representation.
How?
Because the direction was given by this earlier by this Hon'Ble Court to
OP number 1
2 only. Because
you, if it is your duty, you take the consideration.
That's it.
If it is the duty of universities, you have power under the Universities Act to direct the university to not to keep the representation pending. Okay?
That's it.
Learned ASC appearing for OP number 1 submits that the consideration of the subject representations has to happen collectively at the hands of all the OPs. And therefore, if a timeline is granted, fixed, there would be no difficulty for considering the subject or said representations in accordance with law, keeping in view the decision of this court cited above. First, next paragraph. In the above circumstances, petition is disposed of. It directly consideration of the subject representations within a period of 8 weeks in accordance with law and keeping in view the decision of this court cited supra. First, next paragraph. Is open to, next class. Registry to send a copy of this order to OP numbers 2 and 3 by speed post immediately for consideration and taking needful action. Okay.
so OP number 1 will be considered the representation.
Correct. 11. Next.
Item 23.
This is a college, close to college. Way back in 1998 got permission and recognition. Also, state will come to page 65. A proposal was submitted by the principal of the college for constitution of the governing body, and that proposal was considered and approval was made under Annexure 7 at page 74. The present petitioners, they are the president and secretary of that governing body, which was constituted and approved by the director on 26/8/2025. That's look to page 74. Annexure 7. In exercising power of part of section 7(2) of the Odisha Education Act, the governing body of Bir
Constituted
Rule 23 for a period of 3 years with effect on the date of this notification. Does you get it? Now,
yes, is August 2028.
Yes, sir. 26th August 2025.
Yeah.
Yes. Subsequently, on Annexure 8 at page 76, the director cancelled it. And the ground is, you also see that since it was not
inadvertently approved.
And then you also kindly see page 77, Annexure 9. Another committee was approved on 29/2025. This is impugned. It cannot be without jurisdiction. Also look to very same power has been exercised and once a governing body has been constituted, there is a provision procedure how to supersede that governing body available under the statute. But he himself cannot exercise the power to recall it.
No such power.
No such power.
Who can cancel that?
Only that the power is available to file an appeal against the order if in exercise the governing body which has been constituted.
Read the
Yes, yes. So section 7.
7 is approval.
Approval for a period of 3 years.
Yes. If not approved or if approved, matter can be taken in appeal.
That is another party. Not in approved, there is no provision of appeal. But against the permission, refusal of permission, there is a provision of appeal.
If it is approved,
yes.
Then if I have grievance against the approval,
No, there is no such provision in appeal, but there is a provision of supersession. Suppose the governing body acted contrary to the provisions of the
That
act.
is supersession.
Right. That is a provision of appeal there.
You take emergent notice.
Sir, I'll take notice. Stay.
ASC is requested to accept notice for OP numbers 1, 2, 3.
12.
Huh?
Yes, opposite party, all opposite party, because they are the person those who have been taken as members. I have been.
Separate notice he cannot take.
No, he can take. I have taken.
Emergent notice to the rest. Returnable within 10 days.
Yes, sir. This interim order, respect. Because they now that which has been constituted, they will immediately that doing action something to approve the members of the teaching staff and non-teaching staff, which therefore they have come somehow managed to come. That is the problem. No action at least pursuant to that.
Till next date of hearing, no precipitatory action shall be taken pursuant to ensuing order.
Under annexures,
That's annexure.
annexure 9.
Annexure 9.
Order
20 September 20.
September 2022. Passed by the director.
Item 24.
Item 24, pension matter, notice may be issued. Similar matters are.
Emergent notice. Call along with WP number. ASC accept notice for
Yes.
OP numbers 1 to 4. Emergent notice to OP 5. Do you have any connected matters?
Connected matter I will give.
Yeah.
Item 25.
May please the court.
Yes.
Your Lordship, I am challenging in this present writ petition the second final answer key which was released by the OSSC. By
Final revised answer key.
Yes, Your Lordship. Annexure 5.
What is the mistake in that?
Your Lordship, I participated in the exam, leave teachers training examinations, pursuant to which a tentative answer key was released on 27/5/2025.
Now it is changed.
No, yes, Lordship. In this case, what has happened is they have issued two final answer keys, pursuant to objections which they received to the final answer key which was released first.
You mean to say the first key answer sheet?
Yes, Your Lordship.
Should be the basis.
Yes, Your Lordship. First final answer key should be the basis. On 27/5/2025, they released the provisional answer key. They invited for objections and very categorically they state
why they use the word answer key? It's a key answer.
Key answer. Your Lordship, if I may.
No, I have understood the case now. You take emergent notice. Let us see.
Yes, interim protection may be
What
granted.
interim protection?
I've prayed for one seat may not be filled till.
Issue emergent notice. First off, till learned AG is requested to accept notice for only one OP.
Yes, staff selection.
Staff selection.
OP number.
Department.
There was panel advocate, na? Very effective panel advocate is there for selection.
Mr. Patnaik was there. S.N. Patnaik was there.
Sir Patnaik, learned panel counsel is requested to accept notice for OP number 2. Petitioner to serve copies of petition along with all the documents along both on ASC and the panel counsel right now. First counsel for the petitioner submits and this court agrees that to ensure that the petition does not become infructuous, one post of LT or teacher Sanskrit be kept vacant. First, ordered accordingly by way of interim arrangement.
Much obliged, Your Lordship.
I dispose of.
Item 26.
Item 26, my claim for UGC scale up pay that has been rejected. Your Lordship may issue notice.
Today this order will be urgent document today.
Yeah, today.
Most of that day. Because
I will not go home without posting the orders.
holidays are there, but not 20th posting day.
Even otherwise, I will do. In holidays, you need a lot of fee.
Upload.
Youngsters will need a lot of fee now because holiday is coming for about 5-6 days. Court will not be working.
Hello,
I have kept that in.
the order is not reflected. That was the copy pay section is not providing that way.
Yes, I will do.
here my claim for UGC scale of pay has been rejected. Your Lordship, may I so note?
Similar matters we have.
Yes, yes. Notice has been issued.
ASC, Mr. ASC, AG, Mr. Mohanty requested to accept notice for 192, emergent notice to 3. Please. Yes.
Item 27.
May it please your lordship.
Yes.
My lord, petitioner was an employee and he was arrested on the accusation of
You are seeking reinstatement.
reinstatement with all benefits.
Benefit acquitted in the criminal case.
Yes, my lord. That
No
your,
disciplinary inquiry was held.
no, it is not. No appeal also filed. And your lordship may kindly see this honorable High Court.
Consider suppose if an employee is removed on the ground of criminal case. Okay, without disciplinary inquiry, and he emerges victorious in the criminal case, then reinstatement is the rule.
They have filed the repentance because it is a POCSO case.
Whichever case, you should have held disciplinary inquiry. If you can disagree with the findings of the criminal court, but when there is only a criminal case,
Disciplinary proceedings.
yes, you consider that representation in a time-bound way.
M.S.SAHOO case, this Honorable High Court, relying on the principle decided by the Honorable Supreme Court in Ramlal case, granted benefit even
Ramlal case is a honorable acquittal. That will not.
Here Honorable acquittal. Here Honorable
Acquittal.
Yes, yes, your lordship. And thereafter, on the basis of M.S.SAHOO, two other judgments of this Honorable Court is also there. The first
is sufficient. Law declared by the Supreme Court under Article 141. 141 does not say. Law repeatedly declared by the Supreme Court. The short grievance of the petitioner is as to denial of the OP's reinstatement, even when he has emerged victorious in the subject criminal case. First off, counsel for the petitioner submits that in the light of Ramlal versus so and so, followed by, which is that Karnataka judgment, which followed Ramlal. Huh? Anybody? 2025 judgment, is there one? P.V. Rudrappa versus state, his client ought to have been reinstated since he has secured an acquittal order which is honorable in nature in the light of P.V. Rudrappa. P.V. Rudrappa's citation? That citation. Counsel also submits that he has already made a representation dated
under Annexure 1, page 10.
Dated.
Date 13/2/25.
13/2/2025 at Annexure 10. Wherein Annexure 1, wherein he has sought for his reinstatement. First, he complains that no decision is being taken on the said representation, which is already more than 8 months old. First off, next paragraph. Learned AGA Mr. Mohanty, having accepted notice for the OP, very fairly agrees that he would instruct OP number, which OP?
OP number sole opposite number 1.
OP to take a call on the subject presentation if all contentions are kept and a reasonable timeline is prescribed by the court. First, with this proposal, consent for the petitioner is also agreeable. Next paragraph. In the above circumstances, petition is disposed of. 6 weeks to consider the representation in the light of Ramlal.
My lord, if preliminarily my lord says directed the notice, it is to be disposed of.
Yeah, disposed of only.
Disposed of.
I have requested you to accept notice. Then you take a decision. This is an order to pass order
in the representation.
In the representation, but representation should happen in the light of Ramlal. Because you have not instituted any disciplinary.
Ramlal and Rudrappa taken.
Yeah. One sentence short. The records disclose that though the criminal case was filed, No disciplinary action. Proceedings were introduced. Next one.
In those decisions, with all benefits, it was ordered.
Open to solicit any information, etc., etc. Okay. Brother, we'll make it 8 weeks. 6 weeks will be too short. Unnecessary.
Most 8 weeks. From the date of presentation of the certified copy will be.
No. This is today, from today. From today, 8 weeks. Because I am posting all the orders. They can't say that certified copy has not reached this, that, etc.
Item 28. May I please? This question to the gradation list. Objection was invited. I also filed the representation claiming that this seniority as a head server. Lordship also passed the identical issues
in identical matters. What we have done?
Lordship, with consider the representation
before yesterday.
Your representation is dated what?
That Lordship, that is annexed.
This is on
14/7/2025. Same, but the paragraph 1 of the order has to be corrected. The prayer of the representation should be corrected.
Instead of this, put petition prayer here.
Page 43, the prayer of the representation.
No, you rectify it and rectified order.
All three are same.
Yes, all three same. This photo, 1 key for please.
Item 29.
May I please minute? Minutes, I beg to appear for the petitioner in the matter.
You need not beg at all. It is your right. Why are you begging? Then one has to go to the temple. You need not beg. It's your right.
I'm sorry, my lord. Yes, I appear for the petitioner, my lord. It is a temple of justice anyway.
OP number 1.
Petitioner.
Balance amount of quashment and concept notice.
Yeah, my lord, notice was issued.
My lord, petitioner is a registered society, my lord. And I was handed over certain cattle which were rescued by the state authorities for the purpose of maintaining them. This is an admitted case, my lords, that as on today, I'm taking care of about 160 animals, and I'll just take my lords through the pictures to demonstrate that in what state I got custody of them. So, my lords, there is a statutory funding to which I'm entitled, and the state, despite my repeated request, I've still not gotten my statutory funding for that purpose, and that's my grievance, my lord. If I may just place the requisition letter by which the cattle was first placed in my custody. My lords, I may request my lords to come to page 24.
Yes.
My lords, this is a letter of 12th of October 2019, whereby I was requisitioned to provide shelter to the seized cattle. The letter says, with reference to the case and subject cited above, I am to inform you that 388 cattle has been seized yesterday, that is on 12/10/2019, near the village so-and-so, from 6 numbers of contingent, which were transported in very cruel and inhumane manner. It is not possible to keep them at PS. Hence, it is requested to provide shelter to the seized cattle, and the necessary funds will be provided for their care and maintenance by the district administration, so-and-so, as soon as possible, as per the telephonic discussion. Now, if I may just request my lords to have a look at the pictures, just to demonstrate the state in which I got the cattle. My lords may come to page 309, my lords. These were filed by way of additional documents. PDF page 309.
309.
309, my lords.
Yes, go to 309.
Yes, my lords. These are some of the pictures which were only to demonstrate as to this is the state, my lords, in which I had received the cattle. And my lords, I have been taking care of them since then.
1 second.
I'm sorry.
See the kind of treatment.
I have gone.
Will Durant, the famous historian, say,
Part of the.
Hear me. Will Durant and Ariel Durant, the couple, who have written the story of civilization in 11 volumes, they say The standard of civilization can be measured by the way the people treat the animals. What kind of, see, I cannot see it also. Appalling it is. Why money is not released?
Well, part of the same has been released.
What means what?
Well, because 388 cattle, it has been seized.
Remove that photograph. Don't put it to me. I get disturbed. I cannot decide other matters. Yes.
388 cattle has been seized. Some of them has been returned back to the person concerned. Some of them have been retained by the petitioner so far the Gosala is concerned.
Correct.
So as per the new act and rules, the care and maintenance rules, so it's not a contract between the state and the petitioners, Gosala. But they have to be retained because it is our duty, Mala, taking care of these animals. I am conscious.
Directive principle.
Obviously, Mala, it is our duty also.
Yes.
Otherwise, we cannot survive.
At all.
At the same time, so far this amount is so high because year-wise we have given in the reply, so whatever the amount. So in first phase, 4,86,000, subsequent to 1 lakh, not that it has not been remitted, but residual part has not been remitted.
When are you going to remit it? Simple.
So because state has to bear all this cost,
Which
and they are also taking care of. Right, we are also taking care of. We are also taking care of.
You spend, see, I will not deliberate more. You spend crores on things which may not be warranted.
That's
I
true.
need not specify.
That's true, man. That's true.
Crores are being spent. Crores on advertisement as to what the government has to. Crores. I will not say more because I have some constraint.
My lord,
I will say more.
being
the next
conscious, my lord, I go down.
When are you going to?
Only, my lord, D1 for a moment to the counter.
Yeah.
D1 for a moment, me.
Yes.
May I invite your kind?
What you have released is true.
Yes, ma'am.
But there is a calculation, there is a method as to the amount you have arrived at. That amount has to be released. Why part? Suppose if part amount is released as fees to you and part amount as salary to me, that will file repetition.
No, my lord, residual part has not been released to other person, my lord. That is not the dispute, my lord.
But in fact, something has to be done, Mr.
My lord, 1920, 2021, all the way.
This is a land.
No, it's a sacrosanct duty, my lord. I cannot say no to it or regulate of this problem. State cannot. But because of the amount is so heavy, because
heavy.
16 lakhs, 20 lakhs,
reduce unnecessary expenditure and divert it to these things.
So we'll make it convenient. We are going making
When
it
are you
convenient.
going to?
Financial aspect, definitely I need instruction because
Time, no problem. Tell me on which date you will do something.
give me 10 days time. By that I will come.
All right. We'll give 10 days time. Okay.
My lords, may I just seek one indulgence, my lords?
Yeah.
My lords, this is a matter which I would like to assist my lords by physical appearance, and my apology for not being there today. Would my lord consider fixing it somewhere in the second week of November, subject to my lord's convenience? So that
On 11th of November?
my lords,
11th of November.
my lords, the second week, my lords, week thereafter.
Second week. You choose a date from the calendar.
11th, second week also.
My lords, any date after 11th, my lords, 11th is a problem.
All right. On 13th, all right.
Very well, my lords. I'm so grateful.
Mr. Monty, you have to do something.
Yes, ma'am. Yes.
Just see the photograph.
Yes.
No,
that is everyone.
having their heart at the right place. Not at the right place means right and left. Yes.
Grateful.
30. Yes, doctor.
Milords, I kindly have a look at Milords order dated 12/8/2025 minutes.
12/8/25.
Milords, it's a case of admitted dues, Milords. Milords, the opposite party have admitted in the affidavit that the amount is to be given to the petitioner, Milords. Milords, since 12/8/2025, Milords, the state...
Other component is not yet clear. Yes, brother, what do you say?
Milords,
Other day your senior appeared.
yes, Milords, my senior appeared, Milords, the other day.
That's what has been done, Mr.
My lord, last occasion, Malvisha has also passed order on 12/8.
Correct.
2000.
Kindly read para 2.
That is para 2, 33,90,000 that has already been disbursed, Milo. The residual part, they have sought for this concurrence to make it convenient, Milo. That is not disputed, Milo.
Yes.
So it is some crores, Milo. So
maybe in crores, what to do?
My lord, I'm outing this response, Milo.
This is the taxpayers' money, Milo.
This order was, one second, sit down.
Yes.
Please sit down.
My lord,
12/8 to 12/10. How many kilometers away the government is from the seat of court?
My lord, I have received the instruction also last occasion, Milo.
Yeah.
But in the amount of security, price escalation, everything it has been integrated.
After that, how much money to be paid?
Apart from that, it is around 4 crores some odd.
Yeah, you paid. Thereafter, we look into what is payable, what is not payable. Let us see. Whatever is admitted liability.
Well, that is the total amount, Milo.
That is the total amount.
Amount.
That's your case.
Yes.
But pay that. Then we'll adjudicate rest of the things. When are you paying? Even according to you, 4 crores. Do you know the amount of cost the government has paid to the employees pursuant to order of the apex court? 1.5 lakh to each of the employees.
That is Sudhanshu Jana.
Because of your mistake. Because of your mistake, several crores of this money is spent.
That
because of mistake of the government. Yes. And for these things, there is no money. For those things, you have abundant money. And the word those includes many other things also. Why money?
Give me some reasonable time because it is financial concern. I am concerned.
Mr. Monty, 2 months are over. Order was made on in August. You tell me on which date you are making the payment. I will give you time. Because admittedly, 4 crores are payable. Admittedly.
No, my lord. That is the things nothing is remain there, my lord.
Your
total amount is that much.
But you are saying that you are waiting for the approval.
Exactly. Out of that 3390, it is coming around 34 lakhs. Has already been paid, my lord. That is not dispute. Apart from that, other 4 lakhs. There are about 4 crores. Sorry, I'm 4 crores. May I take instruction, my lord? Exactly. So for the financial aspect, it will be embarrassed on my part to
call this matter on 17/11.
17/11.
Yes. At the request of learned AGA Mr. Mohan, who assures to come out hopefully with positive response.
Obliged.
Yes.
Item 31.
Item 31.
Yes.
This is matter led to admission in the Kendra Vidyalaya in the year of 2022. He is applied for the admission into Standard 8. In the meantime, 5 academic session already over and matter already been stayed by the Supreme Court. All the against the judgment passed with the
High Courts.
High Court, this High Court, various High Court. That is regarding sponsoring agency quota that is abolished by the KBS. But the writ appeal judgment passed by the Kerala High Court that was confirmed by the Apex Court. The writ appeal judgment dismissed filed by the KBS before this court, that was the stayed. And yesterday I have downloaded the judgment of the order of the Apex Court. That is stage continuing before the registered court and list again on 24/11/2025.
Because the petition was filed.
Now he is perhaps reading in 12th class in other.
Learned counsel for the petitioners have made. Learned panel counsel appearing for the answering OPs does not dispute that the matter as having become infructuous needs to be disposed of as such. First, ordered accordingly, and writ petition is disposed.
Okay, sir.
Yes. Yes, sir.
Well, in the case of the petitioner prays for approval of his appointment of the petitioner who is working, who is a teacher.
Recommendation by OP3.
Well, recommendation by OP3, my lord. And also And Lord, these already everything already completed. Lord, the school already submitted all documents. Lord.
Same as that is the impugned order Annex 9.
Impugned order.
My Lord, they have rejected.
They have rejected. So notice is to be gone.
AG accepts notice for.
Notice will not already issued. My Lord.
Let us see.
File counter.
AGA to file counter within 3 weeks. Filling with right to file 1 stands forfeited. Yes.
Item 33.
No, let it be 4 weeks.
May it please, my lord. My lord, I'm appearing in VC, my lord. My lord, in this case, what happened, my lord? Kindly have a glance to page 19, where the petitioners are already regularized. Now they are
There are similar matters posted to 3rd November, 2nd week of November, madam.
2nd week of November.
My lord, WPC number 32119 of 2023.
Issue notice. Who appears for whom?
My lord, I am appearing for University of Uthal University.
AGA for 1. Totally for
my
first
lord, in this matter, counter rejoinder already been filed, my lord.
In the
2 and 3 is 2.
in the 27. Okay. Next.
My lord, may I pray 26th?
26.
Great.
Item 34.
May I please balance.
Yes, sir.
Page, my lords, I have been appointed by way of an open advertisement on ad hoc basis as a contract teacher.
So in the professor in sociology.
Sociology. And that is Central University, my lords. In
who is your opponent?
My opponent is Central University Council, Mr. Behera, probably.
Behera is not here. Notice was issued.
My lords, on last pleadings are complete on last 4 occasions. He has been taking time on some plea or the other. And today
difficult because many other we have a division bench also. We'll have this in the first week of December.
Last this is the
last week.
No. This is the my difficulty is they might fill up that post. I have been in the 49th board meeting. I was appointed. Then they arbitrarily rejected took me out. And in the 51st, they said that no, you have not been duly appointed. Their counter is that I have been appointed by a duly constituted committee. When I give my rejoinder, then they say in reply that no, your committee may be duly appointed. Now another ground that there are other difficulties. But the UGC guidelines under which, the advertisement guidelines under which I have been, my selection was made, clearly says that your past records will be taken into consideration as a contractual teacher. Now they have given me because I was working under them, they have given me the experience certificate for 14 years.
Yeah.
And in the selection, they say that our certificate is not. And then another similar case, very similar for Oriya, one Rudrani Mahanti, one lady, similar, same as she was appointed in the same batch as me. Her appointment was also contractual. They used that same certificate to her benefit. They gave her the appointment. And in my case, they say, when that was pointed out, the counter, they say, we'll look into it. I mean, this man is playing with my career, this VC.
Yeah.
I was only praying, Your Lordship, I called it in the second week of November, so that...
second week, we have more matters. I'll call it on 19th.
November 19th. Lordship, I kindly say peremptory. No, I know it's a little...
Call this matter on 19th to enable counsel for the OPs to come and argue.
Lordship, indicate no further adjournments. At least indicate.
Sometimes I have to take a...
I'm sorry. So I'll not push for it.
Let us see.
At the interim, there's an interim order.
Interim order to continue.
And the post also, one post may not be filled up. So they have not done anything.
Whatever interim order is there, that will continue.
Item 35.
Non-payment of pension, I am before your lordship. Since May 2023, I have retired. And in the meantime, I have also been regularized in service by virtue of the order passed by this Honorable Court. I have put on about 33 years of service.
Yes, brother. Yes, my lord. We have already paid the blood amount, my lord. Your lordship would pay 10 of my counter. 24 lakhs 77,000 we have already paid, my lord.
You have paid towards
area of other benefits, my lord.
Who should pay this?
The university will pay. University will pay, my lord.
University has paid.
Paid.
It has already paid to you.
No. It has paid so far as area of salary is concerned. After regularization of my services, about 10 to 15, they have all have been regularized by virtue of the order passed by this Honorable Court. And he is harping on that. But I have retired on attaining the age of superannuation in May 2023. In the meantime, 2 years have already been passed.
Pension is not paid.
Pension is not paid.
Pension is payable to you.
Yes. I am entitled to pension and 3 of the employees similarly situated already paid.
My lord, it is a state university, my lord. The state government is necessary party, but here last your lordship also on other bench direction to state government is necessary, but still state government is not a party. So it's a financial, the university depends on financial from the higher education.
Whether it is pensionable job or not.
Initially it is not pensionable job, my lord.
Now it is pensionable or not?
No, my lord. Only
it is not pensionable.
No, my lord. 3 candidates filed this is on the court, and that order also challenging, also contempt is pending. So that I pay one thing, my lord, state government is necessary party. Also state government.
My lord.
On 26th we will consider, not today. But today we
26, yes. But so far as the state government is concerned, my information is that state has already given the pawn. They are playing with the
letters.
26.
Yes.
Let's see.
I will be reverting in a couple of seconds. I said commercially 18 plantations. And they had 18 plantations. 2000. The Color Supreme Court. Yes.
Item 36.
Yes, Mr. Dawes. Well, that's it.
This case, my lord, the short point first for consideration as to whether when the employment started in one set of rule, after bifurcation of the cadre, there are 2 separate of rule. But I have been forced to join in a particular group of service without asking for an option. Had I been, that is affect my service condition. This is
I'm not taking any final disposals. Except short matters. We have some pressing work. Therefore, we'll fix a date.
This is the only point I have stated. That's the only thing. I got a judgment of
28, 11?
It is 11. 27. Better.
27. Yes.
Item 37.
Briefly, dollars. I am giving a debt chart, my lord.
Covered by the judgment?
Pardon me?
Is it covered by the judgment?
No. My
government only, I'm there.
No, I am only issue, my lord. Whether my termination is legal and valid.
Just we consider after vacation, after the holidays.
After holiday.
Can fix it?
You also fix a date.
Because
my lord, since 93 I am contesting this case.
But he is now attained the age of retirement. He is no more in service, his service terminated, and he is a contractor, licensee contractor.
That is my lord,
to be decided.
whether it is applicable or not, it is to be adjudicated. 27.
Let it be on 28, my lord. 28.
28, my lord. November 28.
Again. Yes.
Friday it will be difficult, my lord. Your lawsuit capital 26, my lord, it will get 26.
26th.
Okay.
Item 38. Small matter. Small matter. It is minor.
Yes, let us see how small it is.
My lord, petitioner while working as assistant teacher was promoted to the post of headmaster. He is a 60% permanent physical disability. He filed a petition before this Hon'Ble Court challenge for change of place of posting, my lord, on promotion. This Hon'Ble Court granted stay and directed not to relieve if petitioner not relieved. In fact, the petitioner not relieved, and the petitioner submitted joining report that was not accepted. And petitioner was going to school every day, that was not accepted, and the entire period was treated as leave and due admissible.
Your voice is not audible. From the beginning, you have to start now. Grab that.
Counter is fine. My lord. Small fine.
Legender?
My lord, the petitioner was appointed as assistant teacher.
Your counter has been filed by the state. If at a legender, let the copy.
I have solved the copy.
But I have a copy.
Give one more copy.
My lord, copy. One thing, even though I have joined in the promotional post, I am not giving in headmaster scale of pay since last 2 years, my lord.
That is the only grievance.
No, other grievances.
Grievances are there. Whatever pay is, should be given, it should be given. Na? You can withhold the pay.
Lower post, assistant teacher, I am getting assistant teacher scale. But promotional post, even though I am deciding
post to pay, they are saying.
That salary
after completion.
What is the promotional post? Then salary has to be paid.
Well, let it be for final disposal, my lord, next week.
Disability person, my lord.
Regender be served.
I am solved extra copy, my lord. I have already solved again. I have solved.
1411.
Let them take instruction, my lord, regarding my.
Meanwhile, the permit DGA is directed to ensure that whatever salary is payable as admissible to the post of
headmaster,
It is to be decided.
Is paid to the petitioner. We saw this in the first week of December. Because that exercise they have to do.
That is yet to be decided. In fact,
that is not the grievance.
Unless there is any other issue.
Yes.
39.
Me, please.
Yes.
In this case, the
November last week, December first week, November.
In this case, the petitioner has challenged the order of suspension dated 11/11/2024 by Annexure 1, that is running page 12. 2024, that is running page 12. He was serving as a leader of the aided college, and charge has been framed, that is running page 18, my lord.
Charges
running page 18, my lord.
I am asking the date.
Date is that 2/9/2024.
Charge memo is issued.
My lord, I have also replied against that charge, that is running page 19.
All right. What are the charges?
Charges are that the following charges are framed against you. You are directed to submit the deposition on charges to undersigned on or before 4/9/2024. One is, you were aware of retirement age of ANO as per NCC rules. you have deliberately kept authority of the institution in dark on this matter. That proves your integrity doubtful.
Yes.
You have managed the letter documents very calculatedly for extension of 2 years of service as ANO in your favor in connivance with Professor Sharad Kumar Sahu, reader in Commerce and Administrative Bursa, and submitted the same to CO 6th Odisha Battalion, NCC Puri.
Who appears for the other side?
And the opposite party number 3, Principal Cum Secretary, Surasmal Saha Mahavidyalaya.
How long you will continue suspension?
Petitioner was suspended for misappropriation of fund, forgery, criminal breach of trust.
Annexure 1 में time is.
Annexure 1?
Yes, that is.
Hide Annexure by 3.
Annexure 1, that is the running page to 12, my lord. I had
12. Whereas the disciplinary proceeding was initiated against.
But that has to come to an end. Some
Yes. Committed by him for commissions committed by my lord.
I am not asking why it has been kept so pending since 2/9/2024. He has been under suspension with effect from 11/11/2024.
24, my lord.
2/9/2024 is the charge.
Yes.
More than a year has lapsed.
My lord.
When are you going to accomplish the proceedings?
Stage of the proceeding is not known to me, my lord.
Who knows the stage? Sister?
Also approved Education Department. Also approved.
I have no power, but I am on behalf of the Mr. Maharana. The stipulated time may be fixed also. That is to complete the
inquiry.
It depends on the stage of the proceeding in which.
Very fair. Of course, it depends upon stage. Within 3 months you complete it.
3 months subject, provided he should come forward. He should. Petitioner, yes. He should.
We'll make it a consent order.
Yes, my lord.
Both the sides having argued the matter for some time are graciously agreeable with the suggestion of this court that the subject disciplinary proceedings shall be accomplished by passing the appropriate order within an outer limit of 4 months. 4 months. First off. It is also agreed between the parties that in the event an adverse order is passed, it is open to the petitioner to come before the court again on the fresh cause of action. Ordered accordingly, writ petition is disposed.
Petitioner is cooperating to the that should.
It hardly needs to be stated that while computing the period of 4 months, the adjournment taken by the petitioner shall be discounted.
Yes.
That's all. If he seeks time, then 5 months it will be. What would it? Yes. Petitioner to cooperate with that.
Item 40.
Because of final order. Applications in IA number 25 into insignificant. Yeah.
A very small matter, Lordship, will be finished today, Your Lordship. So, matter is related to change of activities for use of the land, Your Lordship. And similarly, procedural person has been considered, so far my case has been kept pending. What happened in this case, Your Lordship, I have been allotted a piece of land by the IDCO, Industrial Development Corporation of Orissa, Your Lordship, for the purpose of cold storage, Your Lordship. By that time, it was not within the city of Bhubaneswar, Your Lordship. Now it has been adjacent to city. There is a congestion for traffic congestion for
the establishment of IT park.
Yes, my lord. So I applied, Your Lordship, in 30/11/2023. I applied before the opposite party to give permission for changing a policy regarding use of the land from cold storage to IT policy, Lordship. The process of
from cold storage
to IT park, Lordship.
How that under which provision they can?
That is permissible, Lordship. That is IDCO having guideline, Lordship, that I filed in additional affidavit.
No, they have rejected it.
No, they are not rejected. They kept pending, Lordship. The pendency ground is there, Lordship.
that Okaka has not been given permission in favor of His Lordship, thereby he has not been considered. Now, Your Lordship, Okaka has given permission, Lordship. That document I filed in my rejoinder, Lordship. That is, my learned friend is also admitted the same.
If you permit him, say
yes, yes.
Consider the
It's a genuine grievance, but I can't express this thing. But only one paragraph I am reading from the counter. It is also pertinent to mention here that Messrs. Umang Cold Storage, that means petitioner, applied through Go iPass portal for change of activity from cold storage to IT park, right? Application number so dated so that is annexure also 2. The proposal was approved in the 28th meeting of the state level single window clearance authority, SLSWC. However, as per the standard requirement, recommendation from Odisha Computer Application Center OKAK is still awaited. OKAK is the nodal agency for recommending IT.
It has given it now.
My lord,
OKAK has also given the permission.
that document is forthcoming from his rejoinder. In the rejoinder.
You have produced it.
What I beg to submit, let him, he has already moved to the MD. So let him, I have to move the MD. It's not necessary because MD can do it. Your Lordship, permit him that he will submit the documents, everything, and move to the MD, and he will consider and dispose. Considering the one thing also, considering like the consideration made so far the annexure 4 regarding one Anuj photograph LLC. That you can say. 2023 Lordship, I applied and Anuj has been applied Lordship. Anuj consider and they get by my application saying that the OKAK has not been given permission and 2022 IT.
OKAK has given permission.
Yes, my lord. That is a Lordship, my rejoinder annexure 7.
I am asking the date.
26/12/2023, Lordship. That is annexure 7. And IT policy is also annexure 8 he has given.
That's right. Kindly be seated. The grievance of the petitioner.
Lordship only quote the counter statement.
You have read it. Yes. You should leave it to the judge. I may quote, I may not quote it. You have argued the matter.
My submission only, I am concerned.
The grievance of the petitioner is as to long pendency of his application dated 26/12/2023 at annexure, correct?
Yes, ma'am.
Annexure 7, wherein he has sought for...
application is a Lordship annexure. Application is a Lordship. That is a Lordship annexure 2.
Annexure 2. Dated?
That is 30th/11/2023. That we have said
2023.
1/12/2023.
For change of land use. First off, the said application is made to the chairman of Orissa Industrial Infotech Development Corporation. Idco Tower Corporation. First. Next paragraph. Learned counsel for the petitioner submits that where land user conversion is sought for, a decision on the request has to be taken on a war footing so that the purpose of allotment of the land in question is not defeated. First off. Next paragraph. He also submits that OKAK has already granted approval. While letter dated 26/12/2023, a copy whereof awails at annexure 7. Annexure 7. First off. Next paragraph. Learned counsel appearing for the who?
2, 3, 4, 5.
Answering OPs, namely OP number 3, 2, 3, 4, 5. Submits that there was a decision taken by the state level. Which committee? State level?
Single window
committee. On 28th of?
No, that is 6/3/2024.
No. He said 28 something.
The 28/8/2024 said that is so far as the similar situated person consideration.
No, that is different.
28/12?
28/3/2024.
28/3/2024.
23/8, your lordship. 23/8.
23/8/2024 in a similar matter, and therefore now the OKK having given the approval, there would be no difficulty for considering the subject application in accordance with law if all contentions are kept open and a timeline is also prescribed. But that's your submission.
And another point is IT policy was not finalized, but the IT policy already has given. He has given the IT policy annexure.
He also tells that
his
earlier the IT policy was not finalized, although now it has been.
Annexure 8, your lordship.
That's why the annexure 8.
Dated, your lordship, 22/6/2023.
27/6?
22/6, your lordship.
22 June 2023.
Yes, ma'am.
In the above circumstances, this petition is disposed of, directing who? OP number, which OP should take the decision?
OP3.
OP number 3 to take the decision on the subject application within an outer limit of 8 weeks and inform the decision taken to the petitioner so that petitioner, first one. If delay is proved, OP number 3 may be directed to pay heavy costs in thousands of rupees.
That matter, that part.
Yes, that we are putting them to warning.
So let him.
Otherwise, again, on the contempt, second, third contempt, like this, it will go on. If he passes the order, where is the question of paying cost?
Let my learned friend with the copy of the order submit the OP number.
What you are representing? No question of paying.
There's one line can I do? Consideration so far the concession made to other person who is in similar situation, annexure 4, your lordship.
He himself has said that in respect of other.
That line may can be every day, lordship. So that it will be benefit to me.
It was his case, he has argued that.
Then he has cited that document.
That's what.
Annexure 4 he has cited.
It hardly needs to be stated that the consideration should take place in the light of the consideration made in favor of similarly circumstanced persons.
Yes, my lord.
Next.
Observance.
Now, no cause.
Oblige. So do you have next? Item 41.
That matter belong.
Other sheets.
Mark sheets and not declaring the result in time. Although the university came up with saying that they have declared the result, but as per my affidavit and the college report, they did not publish the record. Apart from that, now the question your lordship is sitting over the answer sheets.
My lords, by order dated 24/9/2025 had been pleased to order for an associate professor or an assistant professor to be present to assist your lordship in seeing the papers. Mr. Susekhar Pal, assistant professor reader of the Utkal University, is present here for your lordship. And the sealed copies.
He is here.
Yes, my lord. He's here.
Professor Sir, please come. Thank you for coming here. Yes. Please yield a seat to Professor Sir. Yes, kindly be seated. You are guest of the court now. Yes. You are not a party nor a witness, nothing. You are only the guest of the court. Just look into whether this valuation is proper. You are wearing mask. Are you afraid of court or what?
No, sir. It's okay. I can remove it.
No. If you want, you can. But the lawyers generally do not infect like virus. They infect only the judges perhaps sometimes. Yeah.
I have passed out the original paper.
Yeah, you give papers to Professor Manoj. Yeah, give that.
Kindly excuse me.
Yes, sir.
That
OP number 3 is he has been deputed by the election commissioner for duty in Bihar election. For 1 month he will not there. So instead of that, 4 maybe.
So what do they think? Instead of 3 months, make it 4 months.
OP number 4 instead of OP number 3, it should be OP number 4.
खुला है नहीं सील खुला है नहीं बंद कर दीजिए हाँ खोलिए
सील कवर से
no incidentally one particular envelope was open.
Can I just put a few questions because I'm seeking expert advice. First, I have to ascertain that you are an expert. Your qualification, sir.
Sir, I did my master's from Utkal University.
Utkal University.
And in 94-96. And then I did my PhD at Institute of Physics, Bhubaneswar. Finished it in 2003. Then I moved to his
Your PhD is in which subject?
It was in string theory.
Huh?
High energy physics. And then I moved to Weizmann Institute of Science, Israel for a postdoc for 3 years. Then I moved to South Korea for a postdoc again. Then I came back to India for another postdoc at M.S.SAHOO Institute of Nuclear Physics.
Brother, you have seen his credentials. Very glorious credentials, Professor has got. Do you have objection for his undertaking this exercise? You do not have. Yes. Right now. Professor Science, so give full name. On request of the court, he is present before the court. He is personally present. First off, he has got glorious credentials. First off, counsel for the petitioner rightly and fairly agrees that the professor can make a valuation of the papers in question to ascertain the correctness of earlier valuations. First off, we will give these papers to professor now, and professor will have some time.
Yes.
For doing.
They are going.
There are unsealed covers now.
No, sir. They were in sealed covers, but it has been unsealed.
The answer sheets, they were furnished to the court sealed, earlier. First, they were unsealed and again placed into the envelopes as they were before. First off, the said covers are handed to learned professor for undertaking the exercise. You have to make payment. You cannot ask him to make free exercise. Professor, you can quote one best book which you need to read. I will ask him to get for you.
As far as physics is concerned?
Whichever subject you need.
Okay, so I looked at the case a little bit, and there were 3 papers in that semester.
Thereafter,
yes. So, if you want to suggest the books.
Okay. The personal appearance of the professor and he is undertaking to accomplish the task is highly appreciated and placed on record. First, a carbon copy of this order to be shared with the learned professor by the registry free of cost immediately. Okay. When we should get the matter? How much time we need?
To evaluate all these 9 answers, let's say 2 weeks or so.
2 weeks? As suggested by the professor, a period of 2 weeks for accomplishing the task. Preferably 2 weeks is necessary for accomplishing the task. First off, call this matter on 1911. All right, November 19. That will be 3 weeks. 3 weeks. We'll say 3 weeks so that you'll have other job also. No? It is made clear that the evaluation report shall be submitted in a sealed cover to the court. and the remuneration or reward payable to the professor shall be decided on the next date of hearing. You bring money also. No free service.
No. Not the student, but I'll ask them, parents.
They should do that.
I have a respect. I have also respect for the parents of the planet.
I also read books on theoretical physics. Stephen Hawking, Feynman, Richard Feynman, Richard Dawkins, Rutherford, Chadwick. Wonderful books there. Recently, I started reading The God and the Scientist. One good book written by Müller of Austria. Thank you so much.
I may not be taken amiss by the Honorable Court, but what I would like to put before your Lordship is, if your Lordship quotes a line, gives an opinion regarding that last order, what was the last order and what led your Lordship to go for this exercise, probably with all humility.
Before that, this court-wide order dated 24/9/2025 had said as under. Next, rest of the things. That's right, you're right. Yes. Item 42.
Yeah. Only grievance of the petitioner before your Lordship that the transfer as well as the change of ownership, the land in by the CDA, not in my name. I have approached the authority. Thereafter, the authority has concerned to file affidavit. I also file an affidavit. Since when
transfer the allotment
is
not allotted to whom?
The plot was allotted in the name of my father.
In my father's name. Father is not there now.
No.
So now transfer has to be
in my name.
Change of name.
Change of ownership.
This is almost a mutation.
Mutation.
In my lords, he sought a copy. I send it to my lords.
Where is he sending? Father is dead.
No.
You have to consider his request for mutation.
Exactly.
In a time,
exactly. Why it has not been taken up? That I am to bring it to my lords.
No, not necessary. You do the exercise. He will be very happy. What he does with the reason you are giving, he is saying, my father was the owner. He is dead. And the father of many people will die. My sons also. Then the entry.
Nature.
The short grievance of the petitioner is as to inaction on the part of the OPs in not effecting change of ownership entry in respect of the plot in question, his father having passed away on
your Lordship.
When he passed away?
On 27/10/2017. 27/1/2017.
27/1/2017. First, learned senior advocate appearing for the answering OPs, although initially opposed the petition, now fairly agrees with the suggestion of this court to instruct OP number?
Opposite number 4, your Lordship. The secretary.
OP number 4.
Contact Government Authority.
To accomplish the task if all necessary records are furnished by the petitioner,
permission otherwise also,
but in accordance with law. In accordance with law. If a timeline is prescribed. First up, this is appreciable. Next one, in the above circumstance, petition is disposed of directly consideration of the request of the court. Claim of the petitioner for change of name in the khata and property records in relation to the subject property within a period of 8 weeks.
Yes, sir.
8 weeks. All contentions of the parties are kept over. Because there may be your brothers, sisters, and others also.
They have also filed in their affidavit before the operation.
But there might be some problem then.
It hardly needs to be stated that the stakeholders may be given an opportunity of
Yes.
I also have kept this open, but let us written that way. Because fact remains what is happening. Other than 4 plus succeeded 4.
Therefore, give opportunity.
Yes. Opportunity to be given, there is no problem.
Correct.
But question is that all have a share. Now,
you are not deciding the share.
No.
You are not deciding.
Will include all minutes will. Yes. That is what. This what probably that is the reason for which it is waiting.
Okay.
They say probably that will be recorded in his name.
Okay. Next.
Item 43. Counter filing.
May I please, my lord? My lord, this
So your state does not have Lokayukta?
Yes, yes. It is.
All writ petitions, sir, do you not go to Lokayukta for these things?
It's non-functional.
No appointed. This is there.
Incumbent is not.
Incumbent is not.
Even there the state is failing.
Since
All these matters before the
last 2 years.
Since last 2 years. They think that no Lokayukta is required.
No, PIL is going. No, PIL has been paid also.
PIL is also going. A good thing.
May I please, my lord?
Yeah.
This is a covered matter, your lordship.
Covered matter.
My lord. The judgments are also enforced.
No. How it can be covered? Annexure 9, your lordship, kindly have a look. How it can be covered, my lord?
The judgments that cover the matter are also enclosed, your lordship. Section 11. Your lordship may kindly come to page number 95.
Foundational facts just given.
Annexure 9 is the impugned order, my lord.
9. That
9 ମୁଁ ଟିକେ କହିଦଉଛି ତାପରେ ଆପଣ କହିଦେବେ.
He is a very fair they are very fair government. Yes.
My lord, inviting reference to the subject cited above, I am to inform you that by this department letter dated 22/4/25, you had been requested to call upon a so-called reply to Sri Prabhakar SAHOO, lecturer in zoology, as to why granted benefits granted in favor of him shall not be withdrawn as per provision of under paragraph so and so. So I have submitted so-called reply on ethics, wherein it is admitted fact that
he was not qualified, he was not past MSc.
My lord, at the time.
3.
Sri SAHOO has mentioned that no financial benefit was extended to him from the date of his joining till 17/10/1998. It is a fact that granted benefits under GIA 94 was extended to him under Validation Act, taking into account 5/12/1992 as his date of joining. On the other hand, if he were appointed after acquiring MSc qualification on 2/3/1993, he would not have been eligible for granted benefits under Validation Act 1998, as the cut-off date was 31/12/1992. So his appointment was inherently illegal.
Consideration.
My lord. This
detailed consideration.
My lord.
Not today.
My lord, it requires filing of counters also. We have not filed counter.
My lord, only point if I'm allowed to submit 1 minute. If your lordship feels that it is covered, then your lordship will pass on, or else any other day.
Yes.
I have said that it is covered by the judgment. My lord, fairly is the letter, just the next page, your lordship, 49. My lord, also because of the reason cited earlier, it has been decided to withdraw the granted net benefits extended to Sri SAHOO by department prior concurrence letter such and such and directorate post approval order such and such under 7D of the Odisha Education Act 1969. This particular aspect has been dealt very extensively in this the judgment, that under 7D the personal salary of an employee cannot be stopped. There is a if they wanted to punish me for any of my misconduct, they could have initiated a departmental inquiry, which has not been done. So under this 7D,
the question is, you did not have the requisite.
That I will explain.
Then for that another date is necessary.
That I will explain. Your lordship just again.
Let them file objection. Objections to counter to these five digit tables. Post approval.
Item 44?
Yes. That transfer matter, here your lordship directed the state council to take instruction in the matter because there is no change of place.
No, that's not my lord's query was that I am the petitioner.
Yes.
My lord's query was that since I am a physical handicapped person, and my son is also intellectually disabled of 50%,
On the last occasion, my lords directed the.
But your husband was also working in the
Yes, in the school, but in the same
school.
In the same school where he has been transferred, my lord. The difficulty is that where I have been transferred, that's a girls' high school. My son, where I am presently continuing is a educational institution, so my son is reading with me in that school. So in my new place of posting, my son cannot be a student there since that's a girls' high school. And for that, your lordship director of the London State Council take instruction how the son of the present petitioner can be.
Yes, Mr. G, what you want to do?
Instruction.
There is a child with some disability.
Disability, my lord. It is that school is in a particular village. 2 schools are there. They were transferred from one school to the other in a same village.
In the same place.
In the same place, my lord. The boy is reading in a co-education school, whereas the parents are in a girls' high school. Girls' high school. In a village.
Presence of at least one of the parents is necessary.
Necessary.
In the school. You can organize that very easily.
My lord, here, my lord.
You have so many thousands of schools.
Yes.
You take both child and the mother to some other school.
Mother and the son from. Let me get that inside. Issued them letter.
That's all.
Solve the issue.
Then your problem is solved.
Yes.
Yes. But there is a spouse also. That also, spousal ground also you to keep in.
My lord, within 50 kilometers they will be there.
Very easy.
Let me Lord Senior take an instruction so that where she can
submission.
Yes.
You take instruction.
And she has already been relieved and I have already joined.
But after my status order was passed, I was relieved.
Sometimes the children with different ailment.
But your lordship is absolutely correct. But I don't have any objection on that point. So far as the second writ petition is concerned, your lordship may kindly hear me for a minute. I have filed a writ petition since I have joined and I have been discharging my duties, I am not getting my salary. Secondly, since it is a residential school, my lord, I have incurred 6 lakhs for that school for meeting the expenditure of the inmates of the hostel. And therefore, I have filed the second writ petition. Because of the pendency of the first writ petition, it is neither I am getting my salary nor the...
Yes, Mr. G, if he is working, he should get the salary.
Salary and other expenditure for...
other expenditure that you have to consider.
Yes, yes.
We don't know whether 6 lakhs, it may be 7
yes,
lakhs
yes,
also.
My lord,
3 lakhs
in
also.
both the cases, I will get instruction. In both the cases.
But a salary to be paid to him. Salary, he is working then.
If he is working, the salary should be released. If he is not, if he is moving around...
No. That is your papers I have filed.
OP number 3.
OP number 6.
6. Who has joined the place of the petitioner on transfer.
Yes.
Comma. Is stated to have not been paid the regular salary in these days.
Since 21/6/2025.
That is 21 till these days.
Yes.
From 21/6/2025.
25.
First.
And
in these costly days, comma, peddling the lifeboat without money is really difficult. First term. Therefore, counsel for the petition, the counsel for the said OP submits that a direction be issued for the release of the salary. First term. Mr. G submits that he would confer with his clients and come back, hopefully with positive result.
Yes.
Call this matter on 12/11.
12/11, my lord.
Interim order to continue the first writ petition, my lord.
Interim order. Interim order here.
I have not been relieved. Your
No, see, it has already been relieved.
Your lordship, after passing of the interim order,
Whether you in that post he is working or
Yes.
I am
given all the papers.
I am
given all the
your lordship may kindly say.
He is creating disturbance.
I am not creating. Your lordship may kindly see the order of the.
No, where are you working now?
I mean,
He has already joined.
Yes,
I have, my lord, I have
That is authorities also.
Call your principal over a phone and ask him who is working, whether this person or that.
Yes.
I got it too.
My lord, the order of relief has been passed after the status code was passed, my lord. Your lordship may kindly see.
Your lordship may call
Now, who is working?
In
Mr. G, just
district welfare officer.
over a phone. Whoever is working,
Yes.
to them salary has to be paid.
Yes.
Yes. Next.
Your lordships will take up this matter at 2 p.m.
Yes.
Yes, yes.
Just verify. I will verify from the principal.
Yes, yes, yes. District welfare officer.
District welfare officer. Just over phone you can tell who is he is working or she is working.
Yes.
1045.
Lordship, I'm appearing for OP 15, Lordship.
Yes.
Lordship, may grant 4 weeks time for filing the counter, Lordship.
Also for the opposite parties, praying for time to file counter because we have entered appearance in the last.
Who are for the?
I am the petitioner, sir. Millard, I would like to submit one thing that this opposite party number 4, that is CMG, Cuttack Municipal Corporation. They have received the copy on 6/9/2025. Till yet they have not appeared.
Now they will.
And that is the very important thing that.
No, but I am for the Cuttack Development Authority. I have filed counter. I will be serving copy. There's no problem.
Yes.
I have not received any copy.
I am serving that copy.
He is giving.
And very important thing that in the present context, this entire system, this Cuttack Municipal Corporation will play a vital role for measuring the entire illegal and unauthorized construction of the entire building. The building stands there as entirely, fully unauthorized, illegally, and they have violated the CDA approval letter also, each floor. So that should be given.
Well, this is a case of Graves's father. He was a director of the company.
And he was
a company. He is land. He was the company for whatever reasons that is not known. Now he wants to have that building over on his own land to be demolished. That people have already purchased.
People have purchased illegally. People are staying there.
How can zip code decide?
The prayers are entertainable.
This is it has to be, and because the Cuttack Municipal Corporation will play a vital role. Already they have got 2 notices from us. They did not take any action. That's why the petitioner came to the High Court, to Honorable Court, take a decision. It's illegally unauthorized, and people are staying there in number 3rd, 4th, 4th floor. The life at risk. So the building is totally.
You are also staying there?
No, and my petition.
Their lives are at risk.
Sir, we have the duty, sir. You are my lord. We have the duty to save the life of the people of the poor staying there illegally. The building may collapse at any time. Because my lord.
Show me one ruling.
Sir,
one law, one ruling.
I will show you.
In support of proposition.
My lord.
Third party should look after that people are not.
He was the owner.
How you are concerned with this?
So he was the owner of this property. He was the owner of the entire project. He left the company before 2024. Because of some reason, and they have been. It's a good thing. It's a corruption. It's a nexus between the builder and authority. It's a clear-cut symbol of unauthorized building standing in the mid of the Cuttack city. So we have to take, and here opposite party may give the counter, but the Cuttack Municipal Corporation and opposite 7.
4 weeks. 4 weeks. Who appears for municipal corporation?
My lords, normally, Mr. P.K. Mahanti appears.
Devashish Naik. Mr. Devashish Naik.
Devashish Naik. Okay. The panel council is requested to accept notice for.
My lord, project number 47.
OP number 47.
4 and 7. 7 is for DG Fire and Fire. DG Fire.
DG Fire is a separate authority.
The state government.
The state government. I don't know who is appearing for
that fire safety authority is also party.
Sir,
how many OPs here?
Sir, 16 services.
16 OPs.
16 OPs.
So they are represented.
I think, sir, this opposite number, opposite number party 4 is not appearing. And opposite party number 7, I don't know who plays a vital role because the DG Fire Safety. So they have to.
DG Fire Safety is represented by AG.
By AG.
State G appears for OP number 7.
OP number 7. Sir.
OP number 7. Okay. Call in the first week of December. Okay.
And for OP 13.
You appear for
OP 13.
Yes.
Your Lordship may
will also
maintainability of the
whether he can maintain every nature, my lord.
But have you filed any objections?
No, because we have appeared and thereafter the matter has come up for the first time, my lord.
But then you have to file objection.
Yes, sir.
If you want to raise the issue.
He was there and he goes out and he says everything is bad. Now he files a writ petition. It's a personal vendetta, man.
So let them file the copy. No, we should look at the counter.
Oblige. Yeah. Next.
Item 46.
So, Millard, when the daytime, what the time, sir?
First week of December.
So, please make it for November, sir. The November.
Because many matters we have put. Let them file objections at least.
Item 46.
In this case, I am appealing for the opposite party.
May be directed to serve a copy of the writ application to me.
Brother.
No, not you.
You have to give copy to all whoever wants copy of the petition. Otherwise, again it will be adjourned.
Sir, I have given.
Kindly give me a copy if you have given.
Sir, now he is taking a notice for OP7.
Sir, I will
give that.
And the CD has to serve a notice. So,
Counter matters today matters. Opposite part of
Counter is served.
Sir, my thing is there is only November 1st week, sir.
No,
first week, second week, sir.
No, we have completed lot many matters. Calendar has to fall down actually with the way. Somewhere it is there.
Month of November, sir.
In the month of November.
Sir.
On November 30th. November 28th. Yes, 28th.
Item 46, I am appealing for the opposite party. I paid 4 weeks time to file counter.
4 weeks for filing counter at the request of. Yes.
Item 47. This one, my lord, similar matter, Ashok Kumar Mahapatra, or RSC matter. 47.
Covered by the judgment.
Yes, my lord.
You have changed the.
Change on.
This sentence is by mistake because correct.
48 also same. 48 also.
48 also same. Okay.
49 gratuity matter, government has not filed counter. 49.
49.
We have to file counter with 49.
Counter within 4 days.
49 last item, my lord. My lord, 49 on last item, different matter, my lord. This is the matter covered under Ashok.
49 last item is covered.
Yes, ma'am.
You give a copy to Mr. G, na?
Yes, ma'am.
That last item is 2350.
Last item or first, last item. 237. Sub item no 7.
Wait.
23396 by 25. Last item is 2.
Penalty made.
Last item, my lord, different areas selected. थोड़ा कहीं निषेध हो तो लड़ा असुविधा होगी लास्ट आइटम माय लॉर्ड एरियर मैटर माय लॉर्ड लास्ट
आइटम इज
सब आइटम नंबर 23507 by 25
23507 of 25.
Yes, my lord.
What is that matter?
Matter area salary similar to item number 7.
Item number 7.
Yes, ma'am.
Give that copy. You have done that.
Yes, ma'am. Already issued notice.
Notice is issued, na?
Yes, ma'am.
Yes. But is already issued notice issued here.
Yes, already issued this.
All along with WP number. Yes.
Item 50. Yes. Item 50.
50.
Item issue notice. Now,
I am the.
Yes.
I am the intervenor.
Also to check. Huh?
I am the intervenor in this petition, my lord, and the petitioner come before this honorable court with suppressing of the facts and taking status quo order.
Just obtain status quo order by suppressing facts. Sir.
Yes, my lord.
And for the petitioner, my lord, they are not sought and copy to me, my lord.
You copy. We'll call this matter on 20th of November.
This last week. This month, last week.
This month we have difficulty, na? I call this matter on 30th of October. 30th. In the meanwhile, you give copies.
I also give one. Said same fact, they have obtained the status quo in earlier petition, which was disposed of. And without disclosing this, then second time they have obtained status quo. Same fact.
This date publication is called different, my lord.
No, my
lord. Copy. We'll hear it.
Yes, my lord.
There is interim.
17 matters are posted.
31st to 21 matters.
On 31st is put it. Interim or to continue till 31. Okay. Item 51.
May I please, my lord? My lord, in this case, your lordship had put up very reluctantly to this date on a particular question, your lordship.
Yesterday I filed my counter. It has not come probably. Yesterday I filed counter.
Counter has received the counter. But the point your lordship had, it was that whether this has received the approval of the director or not.
Yes, that
received the counter. The director has not given
the counter.
The director has not given approval, your lordship.
Has not given the approval. Put it on 31. Next week I'm putting it.
Yes.
Item 52.
Then I would copy the.
They tell this. Tell the quotation.
52. Item 52.
51, they have also filed 2 IAs. 51. They let them solve the copies of the
those IAs regarding the mistake that was
one for amendment.
Your lordship had got it examined that he suffers from 55% of disability.
But the IAs you can do.
The modification for modification.
And another for amendment.
Amendment because
what all IAs you have?
Yes.
Share copy.
Counter this
52.
This is a matter that they have blacklisted my vehicle without any show cause or without any inquiry.
They have seized your vehicle.
Blacklisted my vehicle. I am a transporter. Yes, my lord. I am a
blacklisted the vehicle.
Yes.
How blacklisting the vehicle? So instead of that vehicle, you can do another vehicle.
Blacklisting
is a person.
Blacklisted the person with the contract who has taken the contract of the home fed by transporting the milk to different retailers, my lord, from their plant side. They without any notice, without anything, they just blacklisted me from carrying any further business with them, without any show cause, without inquiry, anything, my lord.
You have a very fair friend you have got, no? We'll ask him. Yes, brother, why?
My lord, in fact, in his writ petition also, he had revealed the cause for barring further deployment of the vehicle concerned is because of the theft, which was caught, my lord, in closed circuit camera. And the concerned driver, my lord, who was indulging that, he was interrogated. He conceded the fact, and the reason and the relationship is because of the contract that I have given in my counter affidavit, page 10.
What
it stipulates that the relevant clause is clause 15, which stipulates the federation shall have absolute right to check the vehicle at any time during the process of transportation, loading, either through its designated officials, securities, and impose penalty in the event of detection of milk or other products in excess of quantity mentioned in the delivery challan or invoice. During such searching, which may lead to imposition of penalty, termination, cancellation. Only
without notice to him.
My lord, that the entire action is because of the theft, my lord.
Whether he should know it or not.
He has to. My lord, he was informed. He was informed, driver was interrogated. Notice, my lord, that I have not relied on. That I have not relied on.
Follow that. Justice Krishna IS judgment. Unless a notice is given to him, his rights are affected.
No notice is given.
Just you verify from your rights.
No, I have filed a counter. There, he has not also disclosed anywhere in the counter that they have given a prior notice prior to my lord giving me, blacklisting me. That is the admitted case in the counter, my lord. That is a fairly he has also not.
You notice and take action. I will reserve liberty to him.
In case, my lord.
This may be set aside.
Impugned order is set aside. Field order of blacklisting is set aside. On the ground that no opportunity of hearing for the petition. Personal matter is limited for consideration of fresh at the hands of party number.
All the opposite. Let me be specifically opposite party number 2 should be the.
The short grievance of the petitioner is as to blacklisting of a particular vehicle on the ground that the theft of the commodities being carried in the vehicle happened. First, counsel for the petitioner argues that blacklisting will have serious consequences on his right to business and avocation, guaranteed under Article 91G of the Constitution of India, and therefore such a drastic action cannot be taken sans an opportunity of hearing to his client. First, in other words, he adds that the principles of natural justice being sacrosanct, have not been adhered to by the authority who took the decision, and therefore the same is liable to be set at once. Next paragraph. Learned panel counsel.
I'm one of the panel counsels.
Kindly be seated. Learned senior panel counsel appearing for the OPs opposes the petition, saying that an interrogation of the driver of the vehicle in question having taken place, he confesses to the guilt, and therefore opportunity of hearing, even if was given to the petitioner, the scenario would not have been different. First, next one. Having heard the counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter, in as much as blacklisting is a serious matter which cannot be done unilaterally. Do you have that judgment of Justice Krishna here on blacklisting? First, counsel for the petitioner is writing, telling that principles of natural justice are part of Article 14 jurisprudence in the Constitution, and therefore their violation would give a coherent cause of action. First, next part, in the above circumstances, the petition is allowed. The writ of certiorari issues quashing the impugned order on blacklisting. 7. Matter is remitted to the portal of OP number 1 for consideration of question, after giving a reasonable opportunity of hearing to the petitioner. First, the consideration should happen within an outer limit of 8 weeks. 8 weeks. First, all contentions not kept open. No problems. This Mr. G.
My lord, here is an IA was filed, my lord. Modification of the judgment dated 15/7/2025 with way number so and so.
Modification?
The one Mr. L.K. Mahanti filed.
By the respondent.
Respondent, madam.
Oh, so it's not there.
We have.
You have seen L.K. Mahanti?
My lord.
Today, have you seen Mr. L.K. Mahanti? I think
Yes.
Was he present here? No. I mean, in this sense, was he waiting for us?
No.
He was here. IA 3836 of 2025. The IA has been filed in the disposed of writ appeal number 1232 of 2023. Disposed of.
The thing is, you have to delete writ appeal number 1232. Including the previous to the extent that delete the grade.
1232 is a different matter, he says.
We'll allow this.
Mr. G, but they will say that it is covered.
It's covered. No, it's a different matter.
Different matter, he said.
No, have you checked it? Are you satisfied?
No, I have no copies. He has not served me a copy.
No, sir. You may be right, sir. You do use the paperless brief.
Yes.
Just look at this. So he says that in that batch we disposed
It
of.
could not have been included.
So 1, 2, 3, 2 could not have been included. So you have to check your retapil 1, 2, 3, 2.
My lord.
You have 1, 2, 3, 2.
I have got 1, 2, 3, 2.
Or 17. 1, 2, he has filed it in 17.
My lord. Yes, let me.
Unless you check the retapil 1, 2, 3, 2, you will not get the pleadings also.
Combined experiences.
Disposal of retapil, the batch of retapils,
yes,
WA 17 of 2023, purposefully give all the numbers. 17, 551, 771, 1232, 1292, 1835, 373, and 2473. It is contended by the British respondent in retapil 1232 of 2023 that the said retapil is not similar to the other batch of cases and could not have been included. But sir, the difficulties was hard in that batch.
That's my
Mr. Saroj G, SKG, submits that he shall verify the pleadings of 1232, retapil 1232 of 2023, so as to respond to the contentions raised in the IA. Today, when the matter is taken up, the learned counsel, Mr. Mohanty, is not present for the applicant in the IA. List when this bench functions.
Yeah.
The matter shall be listed when this bench is being
Next. Item 2.
Please, your lords. It is same the batch milord that last item 2473 retapil number. Let's see. That is a regulation matter.
His matter may be deleted from this.
It will be allowed.
Yes.
I have mentioned in IA also that
Yes.
regulation order of this honorable single judge. IA 3876.
2473.
Is not connected matter.
Yes, it is a matter relating to regularization. This matter. It's not a matter relating to pension.
The first two lines are same. Correct. IA, so Mr. Mr. Mohanty for the
I have filed IA.
applicant and Mr. Saroj G, additional government advocate for the opposite party respondent. It is agreed at the bar that this is IA 3876 of 2025. That the retapil number 2473 of 2024 into bracket state of Odisha and others versus Krishna Takri. Bracket closed. Though was disposed of along with the batch of applications, retapil 17 of 2023 being the lead case, then comma, the said the retapil 2473 of 2024 is not similar and also doesn't involve the work charged pension to be granted to work charged employees. Stop. Accordingly, retapil 2473 of 2024 shall be restored to file to be taken up on its own merit by the appropriate assigned bench. IA is favored and disposed of.
Copy of retapil milords, may I have it? I don't have the copy of retapil.
I'm not thinking of, because if it goes, it goes out of the, I mean, our assignment also.
Yes, Lord.
I mean, this bench
I'm
also.
conscious, Lord. Grateful, Lord.
Item 3.
But you were not present on the date of hearing.
No, there is no notice, my lords. No notice has been issued to the, when contempt was moved with the Honorable Single Judge.
Then you came to know.
Yes, there a mention was made that it has been allowed by the Honorable Division Bench. And I checked up with the client, my lord, no notice till date has been made.
So actually, it was impossible for the issuance of notice because it's a batch of cases were remanded by your case is not remanded by Supreme Court.
No, Lordship. In my case, there was a specific order for issuance of notice by speed post.
No, we are not there. These were restored to file by Justice Dholia's judgment.
No, Lordship.
In Sudhan Shekhar Jena. This is not one.
No.
Then you should have pointed out, Mr. G.
Yes.
This should not have happened. Because when you are taking cases,
Yes,
it is
yes.
How do you have a track of what is happening?
Yes,
It is our mistake. No, but he's saying that it never went to SLP. No, it is our mistake, I concede.
In the contempt notes, the statement was made, they are verified.
Yes, please.
Grateful, Lords.
Your Lordships, item 3 today, Your Lordships, I'm very apologetic today, Your Lordship. It's a special bench, but Your Lordships, I have not been able to get prepared. This matter came suddenly. I was actually out of station yesterday. So if Your Lordships will give us another date, but
Miss Bhamirath, along with Manospati is restarting out?
no, Mr. Pati would be not there. I think some other associate of his should be there in the court. He informed me.
No one is there. Senior advocate would so and so for the petitioner. Mr. D.P. Nanda, senior advocate, along with Mr. D. Nanda. Yes. Mr. D. Nanda for the respondent. As per the orders of the Honorable the Chief Justice stated 19/9/2025 in the administrative side, the matter has been assigned to this bench. The learned senior advocate appearing for the petitioner submits that she may be accommodated. So accordingly, the matter stands adjourned, shall be listed when the bench sits next. Liberty to mention?
Lordships.
In the connected matter,
so they'll be
in the connected matter, the order will be the reverse because we are there, the petitioner, and she is the opposite party. So,
connected matter, it has also been assigned or
Both, Your Lordships.
Both the matters.
Okay.
Because it arises in the same
doesn't
order.
show any kind minutes, so that is how I am asking.
They were both attached like even before the
authority jota achanti, Mr. Nanda. Just change karti and the prayer for adjournment is by the non-senior advocate. Same one.
Should we make a mention for the next listing or Your Lordships? I
file that memo before the DR because the only way he track is that this bench is functioning and he will be having that memo with him. He will place it before my lord.
Lordships.
I am having it today break bench, so he collects those and files it.
Lordships.
Any urgency?
No, my lord. This is
Yes, no, his wife is actually suffering from cancer, so that is a little. Because I actually was pursuing this matter to get listed, but unfortunately I was out of station and that is how the whole thing.
their subject, you know.
Because the wife is suffering.
No, absolutely. I was not aware that is so any date subject to your lordship's convenience.
Always move. Then take on lordship's date and fix it.
All right, we'll make efforts. Wait.
Lordships.
You move your memo. And
normally move a memo.
Yes.
So that we have
to take
we will also give that consent so that it is. Yes,
yes.
Yes.
They did sign from Mr. Nanda's associates.
Lordships.